Welcome to the recreation of the Boston Massacre Trial. We've got a great program planned for you, and it's particularly good because it is the 245th anniversary of the Boston Massacre and the 800th anniversary of the Magna Carta. Certainly we're celebrating the rule of law, as we should be tonight. I want to welcome the 2015 Massachusetts State Mock Trial Champions from Windsor School, who were the mock trial champions and the third nationally. And I know they're supposed to be here with us tonight. Are they here? Hey, welcome, guys. Well done. And a special thank you for our sponsors tonight, Leo and Janice Cushing, and Perry and Sheila V. So thank you very much, sponsors. I'm just going to introduce a few people before we get started, and instead of waiting one by one, but do them right together. So first we have our judge, Jack Blakey, a 1988 Notre Dame grad and 1992 Notre Dame Law School grad, who's a judge on the United States District Court for the Northern District of Illinois, and he's going to be serving as judge for our case. Anthony J. Balia of the law school is a graduate of Canisius College and Notre Dame Law School. He clerked for Justice Scalia before coming to the practicing law and then coming to the law school. He's the O'Toole Professor of Constitutional Law, and he's going to offer some comments on the massacre and on the importance of the rule of law, which has never been more important than it is right now. Nico Howard of Notre Dame Law School is also known as John Adams. You know, we shouldn't have done that, but we took the, sorry, BC guys. And Nico is going to graduate in May 2016 with a joint JD MBA. Ryan Snyder, 2012 Notre Dame Law School, a graduate, is second chairing the argument. Ryan just came off a clerkship at the Supreme Court and is at the law firm of Jones Day. Then Associate Dean Alfred Yen from BC Law School is going to introduce the BC participants. So let me turn things over to Fred Yen.
Well, thank you so much for the introduction, Nell, and welcome to all the people from both Notre Dame and Boston College Law School. It's great to see two institutions with such strong connection to academic excellence and the rule of law getting together to do an event like this. And of course, I understand there's a little set to in Fenway Park taking place in a little less than 48 hours, but on that, our loyalties will be divided. Let me take a moment to introduce two people here. One is Evangeline Sarda, who's in the audience. She has prepared our oral list, and she's a graduate of Yale University and Columbia Law School. And then Steve Lebrecq, who is a 2L. He will be handling the argument for the Crown this evening. And he is... He is a graduate of Notre Dame for college and for Boston College in an extra year from now for law school. And so I think Nell may have a couple of remarks before we get going, or otherwise perhaps Professor Balia. So, but thank you very much.
All right, well, good evening. It is a real privilege and a pleasure on behalf of Notre Dame and Boston College to be here for this evening's event. Before we begin our formal proceedings, just allow me a few minutes to set the stage for the events that are going to transpire here tonight, at least as best as I understand them. So we go back tonight in our mind's eye to this city in the winter and the early spring of 1770. At this time, 2 regiments had been housed in Boston since 1768, really for the primary purpose of restoring respect for British law, including customs duties. As we all know, Parliament had passed the infamous Stamp Act in 1765, requiring many printed materials to be stamped and taxed. The act was unpopular among colonists who considered it a violation of their rights as Englishmen to be taxed without their consent. Parliament eventually repealed the act in 1766, but at the same time it reasserted its authority to legislate for the colonists in all cases whatsoever. Under this asserted authority, Parliament proceeded to pass the Townshend Acts, which imposed customs duties on a number of items imported to the colonies. The colonists evaded these duties and organized boycotts of British goods, as we all well know. The soldiers were sent to Boston in 1768 primarily to restore respect for British laws. The colonists resented the soldiers. They resented them for a number of reasons. They resented the fact that they were there to enforce these laws. They resented the prospect of military enforcement of the law. And on a somewhat unrelated note, they resented the fact that the soldiers were here taking their jobs, especially during a time of year when it was especially difficult to find a job. So clashes between soldiers and civilians were on the rise in March of 1770, which takes us specifically to the date of March 5th, 1770. The events of March 5th, 1770 began when a wigmaker's apprentice accused a British officer out in the street of failing to pay his bill. This was a direct insult to the officer's honor and the officer's integrity. A lone sentry stood up on behalf of the officer and told the apprentice, "He is a gentleman, and if he owes you anything, he will pay for it." The apprentice responded something to the effect that there were not any gentlemen left in the regiment. The sentry in turn knocked down the apprentice with his musket. At this, with tensions already high, a crowd began to form. The crowd began threatening the sentry, while at the same time, just blocks away, civilians were confronting other soldiers. With these confrontations beginning to coalesce, Thomas Preston, who was captain of the British Sentries Regiment, reluctantly sent out soldiers of the 24th Regiment to come to the aid of the sentry. The soldiers pushed their way through the crowd, and they fell in with the sentry. Having fallen in with the sentry, the crowd, now growing to the hundreds, began pressing in upon the soldiers, throwing coal, throwing snowballs, hitting the soldiers' muskets and bayonets with sticks, and making other threatening actions toward them. So if we then sort of zoom in on one part of this action, we see that one member of the crowd of colonists, grabs one of the soldiers' bayonets and knocks him to the ground. That soldier, Hugh Montgomery, fired toward the crowd, yelling as he did, "Fire!" More guns fired, and 5 civilians ended up dead in the street. As this was happening, Captain Preston yelled, "Stop firing! Do not fire!" to his soldiers. But 5 were dead. When word of these events reached Thomas Hutchinson, the acting British governor, he rushed to the square. There he found Captain Preston, and he immediately confronted him. "Do you know, sir, you have no power to fire on anybody of the public collected together except when you have a civil magistrate with you giving direct orders." Eventually, amid the scene, Governor Hutchinson made his way to the balcony above the crowd and tried to calm it down. "Let the law have its course," he yelled down. "I will live and die by the law." The next day, with tensions still high, Hutchinson further reflected on the events of the last evening. "I am extremely sorry for the unhappy differences between the inhabitants and troops, and especially for the action of the last evening, and I have exerted myself upon that occasion that a due inquiry may be made and that law may have its course. Well, the law did proceed to have its course. 13 men were indicted for the murder of Boston civilians in King Street on March 5th, 1770, and they were tried that fall. Those indicted included Captain Preston and 8 of his soldiers. The indictments also included 4 civilians who were accused of also firing from the window of the customs house. If found guilty, these men could face death. The accused soldiers at first could not find counsel to represent them in these trials, at least until John Adams and Josiah Quincy agreed to defend them. In doing so, Adams risked a lucrative law practice, and he also risked the personal safety of himself and of his family. Adams was very concerned, however, about damage to the cause of the Patriots if these men did not get a fair trial. Adams was also concerned, at least in part, about his place in history, having a sort of unique appreciation of the events that he was taking part in living out. This was very fortunate for the soldiers because they really could do no better than to have such a renowned son of liberty stand up to defend them. The prosecutor in the case was the loyalist Samuel Quincy. It's interesting, looking back in hindsight, that the job of defending the soldiers fell to 2 patriots, and the job of proving them guilty fell to a loyalist. But this is kind of the point. The main issue at the trial was whether the soldiers acted in self-defense in firing upon the civilians. The instructions that the judge gave the jury sum it up well. If you find that the soldiers did not fire till there was a necessity to do it in their own defense, ye must in such case acquit the soldiers. And if upon the whole ye are in any reasonable doubt of their guilt, ye must then, agreeably to the rule of law, declare them innocent. The trial of Captain Preston lasted 6 days, after which he was acquitted. The trial of the 8 soldiers of the 24th Regiment lasted 9 days, after which 6 were acquitted and 2 were found guilty of manslaughter. Upon pleading the benefit of clergy, they were burned on the thumb and discharged. Unfortunately, tonight's reenactment of the burning of thumbs has been canceled due to time constraints. The 4 men who were accused of firing from the window of the customs house were acquitted very easily. John Adams, looking back, later described this trial, quote, as important a cause as ever was tried in any court or country of the world. If the soldiers in self-defense should have killed any of them, they must be tried, and if truth was respected and the law prevailed, must be acquitted. To depend for a conviction on the perversion of the law and the corruption and partiality of juries would insensibly disgrace the jurisprudence of the country and corrupt the morals of the people. The part I, John Adams, took in the defense of Captain Preston and the soldiers procured me anxiety enough. It was, however, and this is years later looking back, it was, however, one of the most gallant, generous, manly, and disinterested actions of my whole life, and one of the best pieces of service I ever rendered my country. Judgment of death against those soldiers would have been as foul a stain upon this country as the executions of the Quakers or witches back anciently. As the evidence was, the verdict, Adams concluded, was exactly right. So the events leading up to the Boston Massacre and the events that followed upon it were about the rule of law through and through. The rule of law is the idea that a people should be governed by and through laws and not by the arbitrary decisions of government officials or of mobs. Much of the tension in the colonies that led to the events of March 5th, 1770, stemmed from the claim that Parliament violated the rule of law by imposing taxes and duties upon the colonists, contrary to their rights as subjects of England. After the so-called Boston Massacre, without the rule of law, the British soldiers could have been subject to mob violence instead of a trial. Or, conversely, without the rule of law, the British soldiers could have been subject to no inquiry at all, or no accounting at all for their actions. In time, the great Chief Justice John Marshall would describe the United States as a government of laws and not men. This is invariably true, at least to a point. I say to a point because it is, of course, men and women who make and enforce those laws, and the effectiveness of the law depends on their actions. Laws can be malleable, laws can be manipulated, laws can be misused, and their proper application depends on the competence and the good faith of those men and women who participate in their enforcement. So, under a government of laws, the British soldiers were entitled to trial. Under the law, they would be punished if they acted with justification, and they would be acquitted if they acted in self-defense. But at the same time, those laws did not operate on their own. It took people like the patriot defender John Adams and the loyalist prosecutor Samuel Quincy, to set aside their own self-interest so that the laws could generate, in practice, the good for which they were adopted in theory. At Notre Dame, whom we thank again for sponsoring this evening's event, our program on constitutional structure exists to explore and examine the rules of law that define our system of constitutional governance. But we do something more than that, and I know that our great colleagues at Boston College do something far greater than that as well. We remain at Notre Dame, and our colleagues remain at Boston College, ever faithful to our mission to educate men and women to have the wisdom, the competence, and the compassion to ensure, as John Adams sought to ensure, that day by day, case by case, the rule of law fulfills its promise for the common good. Thank you.
Judge Blakey, the courtroom is yours.
Gentlemen of the jury, I have now the responsibility of briefly instructing you on the law that is to guide your deliberations. And after that, counsel for the Crown and the prisoner shall make final argument. The indictment against Thomas Preston of Boston, Suffolk County, alleged that he, having the fear of God before his eyes, but not being moved, but rather seduced by the instigation of the devil and his own wicked heart, did on the 5th day of this instant march at Boston aforesaid, within the county aforesaid, with force and arms feloniously, willfully, and of malice aforethought, assault and cause the death of Crispus Atticus, Samuel Gray, Samuel Maverick, James Caldwell, and Patrick Carr, then and there being in the peace of God and of the said Lord the King. To this charge he has pleaded not guilty, and therefore thrown the burden of proof upon the Crown. I shall not spend any time recapitulating what each witness has testified, especially as your foreman, has taken it in writing from the mouths of the witnesses, but shall endeavor to point out the manner in which the various testimonies are to be considered, and how the evidence given is to be applied, still leaving it with you to consider and determine how far that testimony that has been testified shall be believed. The prisoner is charged with having offended against the common law, and that only. By that law, therefore, he is to be judged, and by that law condemned, or else he must be acquitted. The common law is the law by which the proceedings and determinations of the king's ordinary courts of justice are guided and directed. This is the birthright of every Englishman and the first settlers of this country who brought that law with them. Murder by the common law is the unlawful killing of a reasonable creature under the king's peace, of malice aforethought, by a person of sound mind and discretion. Malice aforethought is not confined to an old grudge or settled hatred against a particular person, but it extends to a disposition to do evil, but not the killing when it is owing to a sudden transport of passion occasioned by considerable provocation. For the law pays such regard to human frailty as not to put a hasty act and a deliberate one on the same footing with regard to guilt. Here you are to determine whether Captain Preston gave an order to his men to fire upon the inhabitants on March 5th. If you determine that he did, you must also consider whether he did so in self-defense. If the captain gave the order but did not do it in self-defense, he is guilty of murder. If he did not give the order, or gave the order acting under self-defense, then he is not guilty. Mr. Payne, is the Crown ready to proceed? Mr. Adams, is the defense ready to proceed? Yes, Your Honor. Mr. Payne, you may proceed for the Crown.
May it please Your Honor and you gentlemen of the jury, I am Robert Treat Payne, and I stand before you as the representative of the Crown. 555 years ago, in 1215 AD, the fed-up nobility of England drafted the Magna Carta. These English noblemen forced King John to sign that great charter upon threat of civil war. Since that time, the Magna Carta has become many things to many people. But the most important aspect of that document, particularly for our purposes here, is the proposition that the king and those who act on behalf of the king are subject to the same laws as you or I. Because of this, those officials are personally liable for injuries they inflict which are contrary to law. The Magna Carta, in a broad sense, stands for this proposition, that all Englishmen are bound by the rule of law. Which brings us to the reason why we have spent the last 5 days in this courtroom. We are here to apply this principle, that the king's representative, the prisoner, Captain Preston, can and should be held accountable for the murder of 5 Bostonians on the 5th of March this year. The prisoner may not hide behind the king's skirts. He must be punished for ordering his men to wantonly kill free citizens of our great city. It remains for me to close this cause on behalf of the Crown. The importance of this case, gentlemen of the jury, is not confined to the small circle of the prisoner and his soldiers. It concerns the very foundations of our civil government. In his defense of the prisoner, Mr. Adams has exhausted every source of eloquence and art. I mention this not as a fault in him, but to guard you from mistaking the flowers of rhetoric for reason and logic. This prosecution is founded on one of the most essential laws of nature, that murder, if suffered with impunity, will annihilate every blessing we derive from the social compacts which knit us together as a civilized society. Your inquiry in this important affair will be directed to the following 2 points. First, did the prisoner give an order to fire, the consequence of which caused the death of any or all of the persons named in the indictments? And second, has the prisoner offered anything to otherwise justify his actions? The evidence in this case is complicated, as both the Crown's witnesses and the prisoners have offered varying accounts of what happened on that 5th day of March. But from the whole taken together, you are to collect the facts. Great pains have been taken to convince you that Captain Preston never gave the order to fire. And if he did so only in self-defense. The evidence placed before you, as well as your own understanding of the nature of the relationship between the soldiers and the citizens of Boston, should convince you that Captain Preston did order his soldiers to shoot, and that he was not acting in self-defense. Let me start with the facts that are not in dispute. The soldiers killed 5 inhabitants of Boston on March 5th. No one disagrees with this point. And because of the prisoner's actions, because of his orders, Samuel Gray, Samuel Maverick, James Caldwell, Patrick Carr, and Crispus Atticus are dead. From the testimony of Colonel Marshall and others, it is unrefuted that there were a number of soldiers patrolling the streets, brandishing their weapons of death and threatening the innocent inhabitants of our city with bloodshed and slaughter. Is it strange, then, that the people were alarmed, that their fears and indignation were excited at this clamorous and hostile appearance of the soldiers? Of course not. Equally true is the fact that the citizens of Boston undoubtedly had as good a right to appear in the square as did Captain Preston and his men. But here's the mischief. Preston appeared to protect the sentinel. But was the sentinel abused? No, for soldiers were there to protect him, so-called peace officers carrying guns and bayonets. Upon this scene entered Captain Preston, who wantonly assumed the entire powers of government and there and then exercised the worst form of savagery, butchering his fellow citizens. In support of this position, you have the testimony of any number of witnesses who swore to his identity, his location, the words which he uttered, and the movement of his lips that accompanied his orders to fire. Mr. Adams points to a few instances of conflicting testimony and determines that you cannot definitively conclude that Captain Preston issued an order to fire. But Mr. Belknap's testimony should end your inquiry. He testified that in response to a direct question from the lieutenant governor, Preston said, "I did it to save my men." Did what? He ordered them to shoot. He was too tired of being called a bloody back and a lobster and other disreputable things. Trying to invalidate all this positive proof, the defense has produced several witnesses to testify that Captain Preston stood in front of his men, while our witnesses place him in the rear. The defense asserts that Captain Preston would not give an order to fire if he stood in front of his men, as that would place him directly in the line of fire. Yet the prisoner's soldiers did fire, and while 5 citizens died, the prisoner escaped unharmed. Mr. Fosdick's testimony explains this. He stated that at the same time Captain Preston gave his order to fire, he moved to the rear, out of harm's way. The defense would also have you believe that even if he gave an order to fire, the prisoner's men could not have heard him because he was in front of them. But again, we have the undisputed facts. The soldiers did shoot. 5 men died. Are you to believe that these professional soldiers, under the watchful command of their captain, would decide on their own accord to shoot at a group of unarmed inhabitants? No. You know these soldiers. They act on command and not on their own volition. The prisoner, Captain Preston, ordered them to fire, and they followed his order. Now, gentlemen, the fact being once proved that he ordered his men to shoot, and that as a result 5 men did die, it is the prisoner's responsibility to justify or excuse his conduct. Mr. Adams has attempted to prove that the people were not only the aggressors, but that they attacked the soldiers with so much violence that it presented an immediate threat to the soldiers' very lives. And that because of such unrest, the prisoner was obliged to order his men to shoot, and the men were obligated to fire upon the inhabitants. This violent attack turns out to be nothing more than a few snowballs thrown by a parcel of boys. Most of these boys were at a considerable distance, as likely to hit the inhabitants as they were to hit the soldiers. What else supports this claim of a dangerous, menacing mob? A stick. One stick. A stick that struck a grenadier, but was not thrown with sufficient force to wound or even sally him. Return to the prisoner's confession to the lieutenant governor. I did it to save my men. To save his men from what? Snowballs? A stick? Why then this outrage, this fury, this abuse? Why then this order to fire? We will never know. But we do know that it was unnecessary. It was unprovoked. It was murder. The prisoner, like all citizens of the realm, is answerable for his actions. The rule of law requires that regardless of position, a man is answerable to the rules of civil society. Whether king or cook, the common law prohibits killing. This is true even for soldiers such as the prisoner. Self-defense is not limitless. A mere touch cannot justify killing your fellow citizens. All of the circumstances of March 5th reflect that Preston and his men were not really in danger. Their actions were not self-defense, but were an overreaction. The law does not protect from such a misstep. In fact, the law of self-defense requires that you take only the action necessary to protect yourself. Let me remind you again, these were snowballs and sticks. Remember, too, the testimony of Mr. Goddard, who said that the soldiers were anxious to establish their authority over the inhabitants. Having protected the Sentinel, Preston and his men could have withdrawn. They did not. Instead, they escalated the situation and fired upon the crowd. A crowd armed with sticks and snowballs. Such circumstances can never justify the killing of one man, let alone 5. I am sensible, gentlemen, that I have the severe side of the question to conduct. I am arguing against the life of an officer, the very thought of which is enough to excite your compassion and appeal to your humanity. But you are being asked to render a verdict not based upon pity or pathos, but upon the facts and the law. If we are to be, as Mr. Adams so often remarks, a government of laws and not of men, then truly you have but one outcome you can reach. It is undisputed that the prisoner soldiers fired upon the inhabitants, resulting in the deaths of 5 citizens of our great city. Mr. Adams points to conflicting testimony and argues that the prisoner was in front of his soldiers and would not or could not have ordered them to fire. But in response to a question from the lieutenant governor, the prisoner admitted to giving the order. He said, "I did it to save my men." Captain Preston gave the order to fire, the consequence of which caused the deaths of Samuel Gray, Samuel Maverick, James Caldwell, Patrick Carr, and Crispus Atticus. Which brings us to our second inquiry. Has the prisoner offered anything to otherwise justify his actions? You have heard words, but the prisoner's actions, even those in dispute, tell the true story. The defense grasped at this distinction between being in front of or behind his men. It is much sound and fury, but it signifies nothing. A claim of self-defense requires a demonstration of the prisoner's fear for his own life. If Preston was in front of his soldiers, then he demonstrated through action that he clearly did not feel fear for his own safety. If you believe, rather, that he was behind his men, then he had nothing to fear, as his own men shielded him from danger. Do not be fooled by Mr. Adams' easy way of avoiding the question as to whether the prisoner truly feared for his own safety. Are we to believe that a group armed with sticks and snowballs caused the prisoner, a professional soldier, to fear for his life? No. Such a conclusion defies both reason and logic. This claim of self-defense simply cannot stand. Upon the whole, gentlemen, the facts are with you. And I doubt not that you will find such a verdict that the laws of God, of nature, and of your own conscience will ever approve. Thank you.
Argument for the prisoner.
May it please your honor, and you, members of the jury. I, John Adams, am for the prisoner at bar, Captain Preston. I shall apologize for it only in the words of Marquis Beccaria. If I may be but the instrument of preserving one life, his blessings and his tears of transport shall be sufficient consolation for me, for the contempt of all mankind. 70 years ago, while still aboard the Arbella, John Winthrop admonished the future Massachusetts Bay colonists that this colony, our colony was to be as a city upon a hill. The eyes of all people are upon us. Winthrop recognized that the American colonies were to be a grand experiment in the application of the rule of the law in its fullest form. He understood, too, that much would be asked of those who ventured here to erect this laboratory of liberty. And because of that, he rallied his cohorts to be mindful that their experiment was not just for them, but for the world. Your judgment in this case shall test how we, as citizens of that city, meet the measure of Winthrop's charge. I pray, as does Captain Preston, that your verdict shall be equal to that scrutiny, and that you will follow the law and the facts. That is to say, the issuance of a verdict of not guilty. Captain Preston stands before you, accused of the crime of homicide. But know first that every instance of one man's killing another is not a crime, much less a crime to be punished by death. The rules of common law authorize a man to preserve his own life at the expense of another's. Those laws are not contradicted by divine or moral law. A person such as Captain Preston may repel force with force against any person who demonstrates an intention to cause him harm. The law considers a man capable of bearing anything and everything but blows. I may reproach a man as much as I please. I may call him a thief, traitor, coward, lobster, bloodyback, and if he kills me, it shall be murder if nothing but words proceed. However, if I am to take him by the nose or smite him on the forehead, that is an assault. That is a blow. The law will not oblige a man to stand still and bear that. There is the difference. Hands off, touch me not, for as soon as you touch me, I am free to respond fully. You and only you must determine whether the Crown has overcome Captain Preston's claim of self-defense. I assert that it has not. Equally true is that the charge against Captain Preston requires a determination that he ordered his men to shoot at the riotous rabble of men before him. That fact, above all others, is in dispute. The witness testimony as to whether Captain Preston gave an order to fire is contested and confusing. You, and only you, must determine whether the Crown has proven beyond doubt that Captain Preston ordered his men to shoot. I assert that it has not. But I will enlarge no more on the evidence. I will submit it to you. I shall endeavor to make some few observations on the testimonies of the witnesses, such as will place the facts in a true light with as much brevity as possible. How much certainty there is in this evidence, I leave to you. The captain's defense is based on two simple points. First, any action taken by him and the soldiers was in self-defense. Second, there is not sufficient certainty as to say that the captain ordered his men to shoot. Either basis supports a verdict of not guilty. Now, we have entertained with a great variety of phrases to avoid calling the group assembled outside the sentry on March 5th a mob. Some have called them shavers. Some have called them geniuses. The plain English is, members of the jury, that this was a motley rabble of saucy boys and outlandish jacktars. If this was not an unlawful assembly, there never was one in the world, and why we should scruple to avoid calling such set of people a mob, I cannot conceive, unless the name is too respectable for them. The sun is not about to stand still or go out, nor the rivers dry up, because there was a mob in Boston on the 5th of March. But what had Captain Preston and the 8 soldiers to expect from such a band of brothers? Would it have been a prudent resolution in them, or anyone in their situation, to sit still and see if the unruly and club-wielding mob would knock their brains out? Had they not all the reason in the world to believe that as the mob had done so much already, that they would proceed further? Of course, the answer is yes. Captain Preston and the soldiers were right to fear for their safety. And once attacked, the captain and the soldiers acted in self-defense. The facts of the soldiers' fear are simple and straightforward. First, there was an attack on the sentinel. He retreated as far as he could and attempted to get to the custom house, but could not. Then he called to the main guard, as he was afraid there would be mischief from the growing number of ill-intentioned citizens. Upon its arrival, the guard was taunted and tormented. The witnesses agree that they saw a number of things thrown and saw plainly sticks strike against the guns of the soldiers. There are many witnesses who swear to circumstances in favor of the accused, including crown witnesses. It should seem impossible that you disbelieve so great a number who swear to such a variety of circumstances as to fall in so naturally with our defense. Did Preston and his men fear for their safety, for their very lives? How could they not? Would you not have been afraid? The scene consisted of dozens of persons with clubs surrounding and overmatching 8 soldiers who were merely standing in the defense of the sentry. Remember that these men were under an oath to stand there, to obey the lawful man of their officer, as much members of the jury as you are to find this case by the law and the evidence before you. But this was not threatening words alone. There were blows. There was a hail of snowball and sticks from a threatening crowd that massively outnumbered the soldiers. 40 or 50 people, some say as many as 100, coming from every point of the compass to the assistance of those that were insulting, assaulting, battering, and abusing them, while throwing every species of rubbish that one could pick up in the street. What had the captain and the soldiers to expect but destruction if they had not taken measures to thus defend themselves? The mob was bent on making this assault, and so too on their own destruction. Do you expect that Captain Preston should behave like a Stoic philosopher lost in apathy, patient as Epictetus while his master was breaking his legs with a cudgel? Unless you say yes to these propositions, it is impossible that you should find Captain Preston guilty. You must suppose him divested of all human passion if you don't think him in the least provoked, assaulted, battered, and fearing for his own life and the life of his soldiers. The law does not oblige us to absorb physical abuse and abstain from action until we are disabled from defending ourselves. The rule of law simply does not require such sacrifice. You cannot require it now from Captain Preston. Captain Preston is charged with murder, alleging that he ordered his soldiers to shoot the mob that attacked him. Let us assume for the moment that you do not believe Captain Preston to have been provoked by the assault and battery of this mob. Let us assume that you do not believe his actions to be in self-defense. What then? Before you reach a verdict of guilt, you must find that Captain Preston did, in fact, order his men to shoot. I will not belabor the point as to the lack of certainty in the charge that Captain Preston ordered his men to shoot. The testimony of Bliss is sufficient to prove this point. He said, "I did not hear any order given by the captain to fire. I stood so near to him that I think I must have heard him if he had given an order to fire before the first firing." The testimony of Andrew the servant, and Cornwall, and Cunningham, and Murray, and Whitehouse, and Woodall is all the same. None heard the captain issue an order to fire. Others have testified differently, saying that Captain Preston did issue such an order. So what are we to make of this disagreement in the testimony? At the very least, there is doubt as to the captain's actions. The law requires that you reach no verdict of guilt unless you are assured by the laws and the fact that one is guilty of the charge. You must be assured of that guilt beyond doubt. But what doubt? I submit that you may not reach a verdict of guilty unless you are sure of the captain's actions beyond a reasonable doubt. That is not to say proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. Rather, it means that you must have in your minds an abiding conviction to a moral certainty that the charge is true. Moral certainty means the highest degree of certainty in matters relating to human affairs. And here we lose the point if argued too much. Rather, let me sum it up succinctly. The disputed facts of the captain's action do not allow you to find with sufficient certainty that those actions occurred beyond a reasonable doubt. He cannot be guilty. As Captain Preston stands before you for his life, it is proper to recollect with what temper the law requires that we should proceed in this trial. We find in the rules laid down by the greatest English judges who have been the brightest minds of all mankind that we are to look upon it as more beneficial that 9 guilty persons go free than 1 innocent person should suffer. The reason is because it's of more importance to community that innocence should be protected than it is that guilt should be punished. This is the rule of law. Thus, the English law has repeatedly stated that it is always safer to err in acquitting than in punishing. It is better to side on the part of mercy than on the part of justice. The best rule in doubtful cases is therefore to incline to acquittal over conviction. Where you are doubtful, never act. That is, if you doubt the prisoner's guilt, never declare him guilty. This is always the rule, especially in cases of life. Indeed, this rule of caution in the face of doubt is not peculiar to English law. But there has never been a system of laws in the world in which this rule did not prevail. It prevailed in the ancient Roman law, but what is more remarkable, it prevails in the modern Roman law still. Even the judges in the courts of inquisition, who with racks, burnings, and scourges examine criminals, even there they preserve it as a maxim. It is better that the guilty should escape punishment than the innocent suffer. The rule of law requires that the swift, sure, and severe penalty of criminal judgment is not rendered without certainty of wrongdoing. That certainty is not the same as knowing that 1 + 1 is always 2, but a sureness beyond the doubt of a reasonable man. That certainty is not present here. There can be no conclusion that Captain Preston is guilty of murder and forced to face the ultimate sanction. Now, facts are stubborn things. Whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. And the law is no less stable than the facts. If an assault was made upon them, the law is clear. The captain and the soldiers had a right to kill in their own defense. Similarly, without clear and uncontroverted evidence beyond a reasonable doubt that he ordered his men to shoot, Captain Preston cannot be found liable in murder for the deaths of the members of the unruly mob before him. I know of no time when a lawyer quite as keenly feels his responsibility as he does at the conclusion of a capital case. This is always true. Since I took this case, I have slept with it, and I have pondered with it, and I have labored with it. I believe in it as I believe in my very life. Yet my belief does not count, for I am not an unprejudiced witness in this case. Nobody knows this better than I. I am a partisan, and a strong partisan at that. For 12 years, I have given the best of my ability that God has given me in service to the law. I have given my time, my reputation, my chances, all this to the cause of the law. Now, I may have been unwise. I may have been extravagant in my statements. But the cause of the law has been the strongest devotion in my life. And I want to say to you that never in my life did I feel about a case as I feel about this case right now. Never in my life did I wish anything as I wish the verdict of this jury. For this case is truly about whether we are to be a people of laws and not men. What does it mean to be governed by the rule of law? It means that we believe in the supremacy of the law, equality before the law, and accountability to the law, even for the crown itself. In short, it means that we believe in a system of government that allows us to be truly free. If we are not to be governed by the rule of law, then mob rule may reign. If we are not to be governed by the rule of law, then you may find guilt despite law and facts to the contrary. Even more, if we are not to be governed by the rule of law, then our American experiment, as envisioned by Winthrop, has failed. And so I conclude. The question before you is this: are we to be a people ruled by the whims of man and the tyranny of the mob? If so, and only if so, Captain Preston is guilty. But if you were to render such a verdict, do not issue it here, not in this cathedral of truth. Let not that travesty bear the light of day. Rather, seek out the darkest and the gloomiest subterranean chamber in Boston, where the cheerful light of truth never enters. There, erect an altar to the mob and immolate Captain Preston upon your pyre of hatred and fear. Or are we still citizens of that bright, shining city on a hill, governed by the rule of law for all the world to see? And are we not, as citizens of that city, willing believers in a system of justice that is steadfast and true? A system that bends to the vindictive wishes of no man or group of men. A system that does what is right, even when that decision is difficult or unpopular. If so, and I deeply pray that it is still so, Captain Preston cannot be guilty. To your candor and to your justice, I submit Captain Preston and his cause. Thank you.
And the judgment of the jury is to be continued. Because after all, the work of the rule of law is a work in progress. I would like to start out in the few minutes that I have to thank our students for a wonderful performance. Could everyone give them a hand? Mr. Lebrecht and Mr. Howard, I know that your professors and your families can be very proud of what you've achieved, and I know that you're going to make great lawyers, and I look forward to seeing you in Chicago in my courtroom. I would, however, recommend that you change your attire when appearing. The practice in Chicago usually is a little bit longer in terms of the pants. During my day job, most people, and you might find this hard to believe, most people are not happy to see me. Civil litigants, they're either being sued or something horrible happened and they have to sue, or criminal defendants, don't even get me started, they're not happy to see me. But there are two great exceptions to that. One is when I get to do naturalization ceremonies and I swear in a group as big as this, and their faces are beaming to become new Americans. And everyone's happy to see me then. And the other time is instances like this. The invitation here on behalf of Notre Dame and Boston College, I just want to thank you for including me in this wonderful evening. This is a wonderful opportunity to talk about the thing that we do every day and the reason why we do it every day. Because when you're in the midst of a brief or an argument or a ruling, you don't get to reflect on why you're doing it and why you love to do it. And we're really honored as attorneys, as judges, to work on something that's part of the human experience in a very unique way. So thank you for that opportunity. But we're here in this wonderful space to talk about history and to celebrate that sacred human achievement of the rule of law. Now, let me talk first about history. The Boston Massacre Trial is famous. It's famous for a lot of things. It's one of the first American trials where the notion of proof beyond a reasonable doubt was involved. It was also one of the first trials where the jurors were sequestered, where they were actually put aside so they would not be influenced by the mob, something that we do today. It was also one of the first trials where the four-man, you notice when I started out it was gentlemen of the jury. That was very hard for me to say because when I normally do it, it's ladies and gentlemen of the jury. It was one of the first opportunities where the foreperson actually recorded the testimony, thing that we do now with court reporters as a matter of course. And it was one of the times where a trial lasted 6 days. Normally a trial at that time only lasted a day. But given the gravity of this case, it was allowed to go on for days. Now a 6-day trial now is ordinary. But back then it was an extraordinary thing. And it was also a trial where two heavyweights went after one another, John Adams and Robert Paine. And 6 years later, both of them would sign the Declaration of Independence on behalf of the state of Massachusetts. So it's a great opportunity to think about history. But perhaps the most important thing we remember from that trial was the rule of law and the exciting example it was for a new country, not quite new then, but on its way to being new, to have the rule of law and to allow it to become important in our lives. And if I would like to just say 3 things, if I can, to add what little I can to the insightful remarks of Professor Bellina. First, the rule of law is not an abstract concept. It's very easy when we have a historical event to think of the players in the story as works of fiction. But the Boston Massacre Trial was no work of fiction. 5 men lost their lives, men with families, with futures, and they died. And additional men, including Captain Prescott, stood in that dock with their lives in the balance. And real attorneys put aside personal hardship. They had bills to pay, a practice to worry about, the safety of themselves and their families, and they put them aside to fulfill their commitment, their professional commitment to something that is the exception in human experience, the rule of law. And they did so, and they set an example. They set an example to American attorneys, and they set an example to attorneys across the world of what it takes to have a functioning legal system. It is not an abstract concept. The rule of law is also to be cherished. The example of history tells us that the rule of law is not the rule, but the exception. Throughout human history, most have lived under oppression and the burden of tyranny and suffering. And we take it for granted. We have it so ingrained in our nature as Americans that we'll stop at a red light when nobody else is around. When we go to Starbucks, we get in line because that's how we live. That's a remarkable and miraculous thing, and we must cherish it. We must cherish it because it is so rare. I also want to talk about the rule of law as something that needs to be earned. Many people lost their lives, sacrificed their fortune, their liberty, the well-being of themselves and their families to give us that right. And they still do it. Whether it's a police officer running into a dark alley, whether it's a fireman running into a burning building, or whether it's our military serving across the country and across the world. They have given the last great measure of citizenship, and we have to earn it. We have to earn what? What is the rule of law? What is the purpose of it? Because freedom is not a spectator sport. If you're called to jury duty, go, serve, because those seeking the rule of law are helpless without you. If there's an election called, learn the issues and decide it. Go and vote, because that is the process that allows us to make change and progress through ballots and not bullets. We have to earn it. We have to earn the rule of law because it gives us freedom, but freedom from what? Simply from tyranny? No, something more. It gives us the freedom to be, to become. What is freedom for if not to live out your life, to pursue happiness, and to order your life according to the dictates of your conscience as God allows you to see it? We have to do that. We have to live out our lives and understand that we can do so because of the rule of law, because there's this cherished thing that we must earn. Lastly, I'd like to mention perhaps another trial. It's a trial that did not end in the rule of law, and it's an important one because it brings up an example of a very important person, certainly a role model for me and for many of us who are Catholic and working in the law, St. Thomas. St. Thomas More was charged with treason, not according to the rule of law, but to the dictates of King Henry VIII. And in his defense, he invoked, at his trial, the Magna Carta to no avail. And he invoked the rule of law. And I'd like to end with a quote, at least as imagined by the playwright Robert Bolt. "And go he should, were he the devil himself, until he broke the law." Why? What would you do? Cut a great road through the law to get after the devil? And when the last law was down and the devil turned round on you, where would you hide? The laws all being flat. This country's planted thick with laws, from coast to coast. Man's laws, not God's. And if you cut them down, and you're just the man to do it, how would you stand in the wind that would blow then? Yes, I would give the devil benefit of law for my own safety's sake. The rule of law came too late to save St. Thomas, but it saved Captain Preston. And it should save each and every one of us if we cherish it, if we earn it. And ladies and gentlemen, with that, court's adjourned.